Is there a dilution of the prosecutorial system in Malaysia? Although the federal constitution has established a sound legal system, the machinations of a small group of people compel us to ask important questions. Is it true that the enforcement of the law is being disrupted by these devices? In particular, three. 1. An attack on the prosecutorial process. Secondly, an attack on the judiciary itself. And number 3, a modification of the rules of the pardon. Is the criminal legal system being undermined? In 3 ways. The first is to charge one's political opponent with a moral misconduct or criminal misconduct, negotiate his release subject to terms, and then to blame the prosecutors and the judges for the outcome and the acquittal. I have good authority. A former Chief Justice and his colleague, another retired federal court judge, both of whom spoke of this just a few days ago. A soon-to-retire judge has also ominously alluded to it. The second technique is to attack the judiciary itself. And the third is to modify, as I said, the application of the rules surrounding the pardon process. Now let's deal with the first device. It seems to be employed in this way. An errant politician or senior civil servant is charged with corruption. There is ample proof of it. For instance, the government parades huge amounts of confiscated property before national media. The government then assembles the finest prosecutorial teams who get to work in earnest. The cases progress, some go to trial, others fall prey to numerous postponements. Then, unaccountably, the accused are discharged by the infamous DNAA order, discharge not amounting to acquittal. Now in this process, the prosecutors are unfairly accused of rushing into the case without securing proper evidence. The implication is that the prosecutors allegedly do not know how to do their job. Now, no greater disservice has ever been done or an insult hurled upon a group of decent, industrious government lawyers who work under tremendous pressure and with little resources. The criticism that the prosecutors acted without evidence is strange. Let's be clear. A prosecutor's work is, you would agree, merely to prosecute. Theirs is a life spent assessing evidence and then applying penal laws to the evidence. If the evidence is adequate, then the accused is charged. If the evidence does not pass muster, no charge can be laid. To do so would be a failure of the officer assigned to the case. One cannot charge someone for fun or purely to intimidate him. So how does a prosecutor obtain adequate evidence? The duty to investigate and to obtain evidence lawfully, that being the operational word, is that of the police, the MACC or other similar investigatory bodies. It is not a prosecutor's duty, armed with a magnifying glass, to fish for evidence like Sherlock Holmes. If it was, he or she would not have the time to attend, you would agree, the duties of the prosecutor or attend court. So what is the government's response to this recent outbreak of DNAAs? Is it the response that the investigators and prosecutors were incompetent or had failed in their duties? This throwing of prosecutors and investigative authorities under the bus, this shifting of blame, is not only unfair to the prosecutors or the professionals in the police or the MACC, it is positively demoralizing, unless this is intended by those in power. That politicians constantly browbeat professional civil servants to do their bidding is not unknown in Malaysia. Who will deny that at a crucial moment when an investigation was ongoing against the then serving Prime Minister, a senior MACC officer was bullied and transferred from his post? Remember also how a serving Attorney General, Tan Sri Gani Patel himself, was suddenly, unconstitutionally and visibly walked out of his chambers on July 27, 2015 by none other than the Chief Secretary to the government, then headed by Najib. Ghani had been leading a task force probing One Malaysia Development Berhad, or 1MDB, and the scandals around it. His abrupt removal led to the perception, which persists to this day, of political interference aimed at stifling investigations. To this day, there is no explanation for these terrible transgressions. In this atmosphere, how can professional investigators, police, MACC perform the enforcement of the law without fearing for their livelihood? Now we go to the second device, the persecution of the judiciary. In 2020, High Court Judge Nazlan Ghazali convicted Najib of 7 charges linked to the misappropriation of RM42 million, or about US 9.5 million, from SRC International. The backlash against him was immediate and brutal. As a serving judge, Justice Nazlan had no means of reply. His office demanded silence. He had to bear it stoically and suffered in grim silence. On December the 7th, 2021, the Court of Appeal affirmed the conviction and sentence. When the final appeal reached the apex court, the detractors shifted their attention onto the Chief Justice, but found nothing to attack her with. They then switched their tirades and focus upon her husband. The CJ said nothing. This was seen by some as part of a broader strategy to undermine judicial authority amid ongoing public protests. The then president of the Malaysian Bar Council remarked, and I quote, "The judiciary's courage and steadfastness is exemplary in the face of numerous challenges and tactics resorted to by the former Prime Minister." Unmoved and aloof, in April 2022, the Chief Justice rebuked the relentless attacks upon the judiciary. In August of 2022, a month later, the BBC, comparing Malaysia's judiciary to those of other Asian countries, hailed the Malaysian judiciary's firmness in the face of terrible odds. It said, and I quote, "The resoluteness shown by Malaysian courts is in stark contrast to the rest of the region." Then came Chief Justice Tengku Maimun's powerful statement. It was no surprise that the same soon-to-retire Chief Justice referred to interference with the judicial processes and judicial appointments. Then we come to the Chief Justice's reply to allegations of religious non-compliance. Because the judiciary had convicted powerful political figures and had made decisions upholding the Constitution, an attempt was made to smear the judiciary with accusations of transgressing religious principles. Tengku Maimun retorted, "Who are you to question the faith of others?" Now, this was no mean feat, for 2 reasons at least. By November 2022, the Malaysian Federal Court, the highest in the country, had a majority of ladies. I quote, "Among apex courts worldwide," reported East Asia Forum, "only the Canadian Supreme Court has had a female majority. Secondly, the last time the head of the Malaysian judiciary questioned the government led to the 1988 judicial crisis. That the current Chief Justice is saying the same thing now after 36 years means that there are segments in the country who think that they can ignore the rule of law. Recently, 9 former presidents of the Malaysian Bar remarked that judicial independence had been better protected under previous 3 governments. Yet, the Malaysian judiciary has up to now proven its independence at great cost to themselves. Our judges have resolutely defended the rule of law. Those who think that the judiciary will be diminished when some senior judges retire may have to think again. which is why it's important that we know how the system functions, which brings us to the third device, the modification of the pardon process. Now, all of these concerns have come down to a single litmus test. How will the courts decide the addendum issue? The court's ability to protect the Constitution and the rule of law is about to be critically tested. The fate of one felon and his hangers-on, it is said, hangs upon a royal decree. Everything, it is said, depends on the addendum and the possibility of a second request for a full pardon. Now, those who clamour on behalf of Najib, who advocate the addendum's validity, disregard the Rukun Negara's keluhuran perlembagaan, or translated in English, the supremacy of the Constitution, and the second principle, kedaulatan undang-undang, the rule of law. In conclusion, I can say that these detractors abhor the decisions of an honest judiciary, hassled, harried, and hounded as it is. They would abandon these foundational constitutional principles and the tenets of Rukun Negara upon which the nation has been repeatedly promised to be administered. Such detractors and those who go against the rule of law would invite disaster to dinner. Thank you and goodbye.